Chairman of Bar Council of Maharashtra and Goa, the coordinator of present CLEP program, Dr. Uday Varunjikar, my dear friend, and all the participants. First of all, I can see from the charts itself that everybody is now today excited about Dr. Varunjikar's birthday. So on all of us, on behalf of you all and from myself, I wish Dr. Varunjikar a very happy birthday and a prosperous, bright future. Friends, today's subject, little untouched topic of we practitioners. We always deal with civil or criminal legislations, special legislations, but the legislation by name Drug and Cosmetics Act, this is put in use in very rare cases, or very few people get such opportunity to work in this under this legislation. Today, in next 40 minutes, the responsibility casted on me is to introduce you all to this particular subject. No doubt, this particular examination, which is going to be held for the first time as per the direction of Honorable Supreme Court, this examination is going to be very crucial. First time such type of examination is being conducted by the authorities. You are well aware that for this examination, not only the lawyers, the competitors to you all would be from law field, or the persons having special knowledge of public affairs, administration, economics, commerce, industry, finance, management, engineering, technology, public health, and medicine. So when all the fields are competing for these particular posts, you please appreciate and keep it in mind that what sort of competition you all going to face. Therefore, I request every one of you that this is a golden opportunity for you all. The syllabus, the topics are very specific. You need to focus on the examination subjects and syllabus. But being a lawyer or being from law faculty, it is your responsibility that you should defeat every other person from every other field. Because naturally, the person who knows law, he knows the intricacies, the technicalities, the ingredients of law, and that is what expected by the examiners at this point of time. So in next 40 minutes, what I'll be covering on this topic would be just a scheme of the act. Thereafter, the essays, which would be part of your paper 2, which would be covering the consumer related issues. So I would be suggesting 4 topics which would be related to consumer topics, but which would be having special bearing on this Drugs and Cosmetics Act. Let us understand that those 4 topics which I am going to discuss would be in respect of these clinical trials which are being conducted in India pursuant to the specialized rules framed under the Act. Whether there are any lacunas in those clinical trial rules, that would be the first topic which I may suggest you for essays. Thereafter, I may also suggest you rules and regulations on advertising, particularly for startups. You are well aware that now these startups are getting so many facilities, so many advantages from the government, but they are not exempted from following the rules of advertising. And then they land up in some difficulties if they advertise wrongly or not as per the prescribed procedure. So that would be the second topic I would be suggesting. Thereafter, I would also be suggesting a topic for essay, that is ban on e-cigarettes. You are well aware that this particular e-cigarette is known as electronic nicotine delivery system, that is ENDS, ENDS. And in September 19, the central government has put complete ban on electronic cigarettes. So how that topic is having some bearing on the Drugs and Cosmetics Act, and that can also be a topic for your essay. And now, and the last topic which I may suggest to you is in respect of telemedicines, e-pharmacy, and robot-assisted surgeries. You are well aware that nowadays you just call your doctor, ask him the medicines, he prescribes that, then you call your pharmacist send those medicines with his peon or a delivery boy, and the work is done. But whether any law is guiding all these transactions, that is also required to be discussed. Then robot assisted surgeries. You are well aware that the first surgery was carried out from USA by a doctor, and the patient was in France, and this surgery has taken place in 2010. So now you will have to appreciate that in respect of such medical advantages or advancements, what law would be covered and guided. So these would be the four topics which I will discuss in the later part of my discussion today. So now let us start with this particular Drugs and Cosmetics Act. I'll just give you a bird's eye view that what this particular act is trying to incorporate or trying to provide. Let us understand that by virtue of this Drugs and Cosmetics Act, the legislature has created three bodies. Friends, I'll request you to either keep your barracks in front of you, or either keep a notepad and pen, so that it would be easier for you to understand the provisions and the scheme of the act. So I was on the point that this act has created three agencies. The first agency is known as Drug Technical Advisory Board. Thereafter, the act has created a central drugs laboratory. And the third is Drugs Consultative Committee. We will discuss about provisions in the act in respect of these three agencies. But just to understand that how the scheme of the act goes, just keep it in mind that these three agencies are created by virtue of this particular legislation. Now comes to the second portion of this particular act, that is the act is providing regulations on what? Import of drugs and cosmetics. Then the act provides for regulations on manufacture, sale, and distribution of drugs and cosmetics. So regulations in respect of import and manufacture, sale, and distribution. That is second part. Now, the act categorizes the drug in three aspects. The first is a drug where you can normally call it as a modern medicine, or you can call it as a allopathic. The second category is Ayurvedic, Siddha, and Unani drugs. So that is the second category this act has made. And the third is cosmetics. So whatever regulations in respect of import, manufacturing, sale, distribution would be provided in the act would be in respect of these three aspects: drugs, Ayurvedic, Siddha, Unani drugs, and the cosmetics. And thereafter, in the last portion, the penal provisions for violations of regulation prescribed in the first part of the act are provided. So this is what the framework of the legislation is. This I have given you just to keep in mind in a simplified manner that what are we going to discuss today in our discussion. I'll repeat it once. The first, creation of 3 agencies. Thereafter, providing regulations on import, management, sale, distribution of what? Drugs. Those are modern allopathic drugs. Thereafter, Ayurvedic, Siddha, Unani drugs and cosmetics. And thereafter, if you breach these regulations, what would be the consequences? What would be the penal provisions? That's it. This is what the act is. Many a times, whenever I try to discuss this legislation with my friends and colleagues, they always get nervous saying that the bare act itself of this Drugs and Cosmetics Act and rules contain 1,000 pages. So therefore, they generally don't touch this legislation. And therefore, I thought that let us give the scheme or bird's eye view or what we are going to discuss about in this legislation in this particular scheme. Now, let us start with the object and reason of this particular act. Friends, first, keep it in mind that this legislation is not in derogation of any other legislation. This legislation is not introduced by repealing something or by cancelling or by revoking any other legislation. This legislation is in addition to the existing all legislation. This you must keep it in mind. Now, let us see what is the objective or the reason to incorporate this legislation. Friends, the objective of this particular legislation is fourfold. First is that regulations of the sale, import, distribution, drugs and cosmetics by means of licensing. See, this licensing part is introduced for the first time by way of this particular legislation. Thereafter, the legislation ensures that only qualified individuals are involved in the import, distribution, and sale of the drugs and cosmetics. Meaning thereby, the act provides qualification for the persons who are coming into the import or coming into the business of this import of pharmaceuticals or the drugs. So therefore, no hanky-panky, no unqualified people, no unprofessional people would be able to import the drugs under the legislation. This is the second object. Thereafter, preventing substandard drug quality, presumably in order to maintain high medical treatment standards. You are well aware that India is now being considered as a medical health or a medical hub in the world. India is also being considered as pharmacy of the world. So these both two sentences indicate that in India, the medical facilities and the pharmaceutical activities are at peak. And therefore, when you try to provide such type of excellent medical facilities, when you try to manufacture good pharmaceutical products, it is essential that some standards of quality are prescribed by the legislation. And if the manufacturers or the persons involved or the concerned in this particular business maintain such type of good quality, only then we can cope up or we can maintain our reputation as a pharmacy of the world. Now, coming to the next objective of this particular legislation. Now, regulation of the production and sale of Ayurvedic, Siddha and Unani drugs. Now, what is this Ayurvedic, Siddha, Unani and all that? The definition part, I will come to that later. But in India, you might have seen that even on the roadside, people sit with their products and saying that I have come from Himalaya and this is the Himalayan drug, or this is some Ayurvedic drug and this is very effective. So such type of persons were coming up in such a high frequency that to control these type of production and sale of our Ayurvedic, Siddha and Unani drugs, it was necessary to put a specific framework, and therefore this act was incorporated. And the now last objective of this act, you can appreciate, is that to form a drug technical advisory board and drugs consultative committees for allopathic and allied drugs as well as cosmetics. Now these boards and committees, they are formulated or they are constituted with the help of experts in the industry, with the help of experts in the government, and they will advise the government as to what would be the perfect way of controlling and regulating this entire business. And that is the way this legislation was incorporated for that aspect also. After completing the object part, now let us move ahead to now what are the provisions and what are the concept prescribed under this particular legislation. Friends, I'll just make a passing reference to a judgment of 2021 passed by Supreme Court. A question was raised before the court regarding validity of certain provisions in respect of this particular legislation. And the Supreme Court, as a way of obiter dicta, has observed that Article 21 of the Constitution of India has given an individual, a citizen of India, a right to have a good health. And in order to give good health to citizens and individuals, it is necessary to have such type of legislation. And therefore, the Supreme Court has categorized this legislation as one of the tools to grant and guarantee right to life to a citizen. Please note down this judgment, 2021, volume 12, Supreme Court cases 674, Union of India versus Ashok Kumar Sharma. Now, friends, coming to certain concepts which are very essential to understand the provisions of law. Now, let us go by the first thing regarding Ayurvedic, Siddha and Unani drug. Now, this is defined under section 3A of the Act. Now, section 3A says that all medicines intended for internal or external use for or in the diagnosis, treatment, mitigation, or prevention of disease or disorder in human beings or animals and manufactured exclusively in accordance with the formulae described in authoritative books of Ayurveda, Siddha, and Unani Tib system of medicine. In short, the definition mentions that there are certain authoritative books which are mentioned in the schedule, in the first schedule of the Act. And the formula to make a Ayurvedic medicine is also prescribed in these authoritative books. So whatever medicines which are for internal or external use or for diagnosis, mitigation, or prevention of disease or disorder in human beings and also the animals, that is called as Ayurvedic, Siddha and Unani drug. Please understand, these are very technical words. You have to either remember these particular terminologies to answer your questions in the examination. I'm again repeating that all medicines for internal or external use, either you consume it or you apply it on the scheme. So external is applying, internal is consuming any medicine for what? For the purposes of diagnosis, mitigation, prevention of disease or disorder in humans as well as animals. So it covers all type of possibilities to call it as a drug, and that is Ayurvedic. So this is defined under 3A. It is also required to be noted that whatever is mentioned in the authoritative books, the list of authoritative books is given in the first schedule of the Act, and the formulas were also provided in that. Only those formulas which are prepared as per the prescription, only those would be called as a Ayurvedic drug. Now, let us move ahead. That the definition of cosmetic. After this Ayurvedic, I'm coming to definition of cosmetic. Now, cosmetic means any article intended to be rubbed, poured, sprinkled, or sprayed on, or introduced into, or otherwise applied to the human body or any part thereof for cleansing, beautifying, promoting attractiveness, or altering the appearance, and includes any article intended for use as a component of cosmetic. This definition, if one reads in a flow, it is really complicated, but I'll try to break it in a simplified manner. See, the definition of cosmetic gives three aspects. First is the form. If a cosmetic, now imagine a cosmetic which you regularly use in your day-to-day life. So it says any article, form is immaterial, whether it is a gel, whether it is a liquid, whether it is a powder, whether it is a paste or anything. So form is immaterial. The definition says any article. Now, further part is mode of use. So how do you use it? Either apply externally. This is for external use only. So applied externally, rubbed, or poured, sprinkled, sprayed, or introduced into the human body for what? Cleansing, beautifying, promoting attractiveness, for altering the appearance. So friends, please keep it in mind. The definition of cosmetics is very broad. It speaks about form of this particular formulation. It can be in any form. Thereafter, how to be used? It has to be used externally by rubbed, poured, sprinkled, sprayed, and then what? It is to be used on human body for cleansing. Please understand, this is not a medicine. This is not for your treatment. This is not for curing your disease. This is only for cleansing, beautifying, promoting attractiveness, for altering the appearance. So this is what the definition of cosmetics is. Now, coming to the next definition or the concept which is prescribed under section 3B of the Act, it says, it speaks about the definition of drug. Now, the definition of drug is also a little lengthy in the Act. So instead of reading that definition, may I try to explain or simplify the definition of drug? Friends, I will request you to concentrate on these explanations, because in your paper 1, there has to be some, that paper 1 is an objective examination. So any type of question is likely to come. And in order to answer such type of objective questions, you need to digest the concepts of the Act. And therefore, I'm requesting everybody of you that you please focus on the explanations or the simplifications I'm trying to make in the definition or the concept part. Now, coming to the drugs definition, it says all medicines for internal or external use of humans or animals used for or in diagnosis, treatment, mitigation, or prevention of disease or disorder, including mosquito repellents. So again, the same explanation which I have given for cosmetics. Please understand this can be taken internally. This can be used externally also. This can be used for humans. This can be used for animals. This is to be used for diagnostics, for treatment, for mitigation or prevention of disease or disorder. And one more thing is added in this, that even the mosquito repellents are treated as drugs. Please keep such things in mind very particularly, because questions are likely to appear in your paper one, that whether mosquito repellent is a drug or no. They will give four options, and you have to choose one. So you have to keep all such exceptional things in the mind very particularly. Now again, coming to simplifying this definition, any form that is powder, gel, liquid, or various or even vapors. So the form is immaterial. It can be in any form. Thereafter, substance which may affect the structure or functions of human body for destruction of vermin or insects, which causes disease in humans or animals. The word used is substance, which may affect the structure or functions of human body for destruction of vermin or insects, which causes disease in humans or animals. Now, further, before going further, I'll just give you an example of this word substance. Kindly give focus on this word substance, because whether a cotton or a bandage, if you have a wound, the doctor applies bandage, a cotton is used. So cotton is in different form. Whether this type of aspect, this type of article, this type of substance can be treated as a drug is a question to you. I will request participants to answer this question in the end of the session. Now going to further aspects of this definition. Now, component of a drug, which includes even the empty gelatin capsules. You are well aware that in a tablet, the actual effective chemical which makes a treatment is very minimal in the quantity, but the tablet is made in this particular weight or form. So whatever is used in a tablet as a component, that can also be categorized as drug. Now you are well aware about the capsules also. So empty gelatin capsules, those are also categorized as drugs. Now coming to next, devices intended for internal or external use. I will give you an example. Now devices, you all are aware that patients of diabetes, few people use insulin pumps. Are you aware about insulin pumps? The insulin pumps are remained attached to your body, and they are programmed that after 2 hours or after 3 hours, you shot so much of insulin in the body. So this is type of a device. So even that device is categorized as a drug as per the definition of drug in the Drugs and Cosmetics Act. So friends, the definition of drug is extremely wide and comprehensively worded. Either it is a medicine or substance or component or a device. I'll repeat again. The drug can be even a medicine or even a substance or even a component or even a device. Now, let us go to some examples. Now, consider a case of blood collection. You know, these blood banks, they collect the blood, they try to preserve it, they try to store it. So by going by the definition of drug, would it cover under the drug? Because many a times drug is this blood is given to a patient who is on deathbed, or who needs improvement, or who is required to be treated only by blood. Few of the patients are, suppose a patient is anemic, suppose a patient has lost huge blood, so blood is required to be supplied, so it is used in form of treatment. So therefore the question came before the Honorable Supreme Court as to whether blood is a drug or no. The question was decided in a celebrated judgment of ESI Corporation versus Duncan Gleneagles Hospitals. This is of 2005, volume 3, CHN 116. So the court held that since blood is used for treatment of a patient, prevention of disease or disorder in humans, it is a drug. Now, coming to a well-known cosmetic, Borolin. There was one case in 1977. The case was very famous by name Abdul Moid versus State, reported in 1977, Criminal Law Journal 1325. So the manufacturers of Borolin, they established that the components which are used in Borolin, those are used for treatment of a patient, and therefore it is held that Borolin is a drug. Now, I'll give you one more example. Many a times you might have seen also that doctor uses some ampoule of a distilled water. The doctor takes that distilled water in a syringe. He mixes it with a powder in some other injection bottle. He stirs it and then administers it to a patient. So whether such water, only distilled water, only a pure form of water, can that be called as a drug, was also a question before the court. In a celebrated judgment, Ramchandra versus West Bengal, reported in 1971 Criminal Law Journal, Calcutta, page 1369, the court held that water used for injection purpose, for dissolving other medicine for injecting into human body, is a drug. I'm giving you such examples just to make you understand that the definition of drug is so wide and vast that any such type of things, even a cotton, even a bandage, even a distilled water, even blood, is categorized under drug as per the definition of this act. Now, friends, I think I'm going little slow, but in order to make you understand certain definitions of and the concepts of the act, it is required to be explained, and therefore we are going little slow. The organizers may note that our lecture may take little more time also. Now, coming to the definition of manufacturing, it is defined under section 3 subclause F. The manufacturing is a process or a part of process for making or altering, ornamenting, finishing, packing, labeling, breaking up, or otherwise treating or adopting any drug or cosmetic for sale or distribution, but does not include compounding or dispensing of any drug. Again, I am saying that process or part of process for making or altering, finishing, packing, labeling, or otherwise treating or adopting any drug or cosmetic for sale or distribution is considered as manufacturing. I'll again go to the example of collection of blood. Now you match this process of collection of blood with this definition. The definition says that process of packing, labeling, breaking up, or otherwise treating any drug or something like that. So even collection of blood is considered as a process of manufacturing. You also consider manufacturing of a medicine also, and the process involved in that. Even a part of process is considered as a manufacturing process. And therefore, this definition in section 3F is very clear on that aspect. Now, after understanding these three major concepts, please understand that as per section 5, the Drug Technical Board was constituted. The central government would constitute such board to advise the central government and the state government on technical matters arising out of the administration of this act. Please keep it in mind that questions have come on these aspects of formation of Drug Technical Advisory Board. Who are the members of this Drug Technical Advisory Board is also one of the questions in objective type of examination. Ex officio members, the Director General of Health Services, who shall be the chairman of such board and all that. But you will have to go through these particular members or their designations or the formation of this particular board very meticulously and minutely. The questions have appeared on these aspects also. Now, section 6 and 7 speaks about Central Drug Laboratory and Drug Consultative Committee. The functions and the roles are prescribed in the rules of the Act, but in a way, the board and the consultative committee are predominantly assigned with the functions of advising the government to make laws, to make particular regulations, to control the malpractices in the entire pharma industry. Now, coming to section 7A, says that nothing contained in section 5 and 7 shall apply to Ayurvedic, Siddha and Unani drugs. Now, what is section 5 and 7? Section 5 and 7 is regarding this Drug Technical Advisory Board and the Drug Consultative Committee. So again, be mindful about the fact that these committees, these technical advisory boards are not supposed to deal with Ayurvedic and Siddha Unani drugs. Now, coming to the concept, the third chapter of the Act, and that is in respect of import. Now, please appreciate one aspect, that whatever concepts we are discussing about the import of drugs and cosmetics, those concepts are used as it is, exactly in the similar manner for manufacturing and sale, distribution of the drugs. These concepts are used identically in case of cosmetics also. These aspects are used for even the Ayurvedic drugs also. So therefore, we will deal with these concepts specifically in respect of import matters, and thereafter we will go to other aspects, but you will have to keep it in mind, the concept like standard of quality or misbranded drugs or adulterated drugs or etc. These are as it is same in respect of other categories of drugs also. Now let us go by the standards of quality. Now section 8 prescribes that for the purpose of this chapter, the expression standard of quality means in a relation to a drug, that the drug complies with the standards set out in the second schedule. So if you see the second schedule of the Act, what should be the quality of a particular drug is mentioned. And therefore, while understanding that wherever the Act says that you have to maintain a standard of quality, what should be the standard of quality, you have to refer to the second schedule of the Act. And that is what prescribed under Section 8 itself. Now, coming to Section 9, that is misbranded drugs. Now, what is misbranding? The provision says that any attempt of concealing the damage made to or appear of better therapeutic value than it really is. That means any process or any attempt on the part of a manufacturer who tries to conceal or damage something in the product so that it will appear to be of better therapeutic value, that process, if it is noticed, it can be considered as a misbranded drug. Thereafter, a drug, if it is not properly labeled in prescribed manner, that is also called as a misbranded drug. Thereafter, if the packing bears a statement of false claim for the drug, then also it is considered as misbranding. So in order to categorize a drug as a misbranded drug, 3 ingredients have to be fulfilled. The first is an attempt of concealing the damage and improving to make it appear of better value. Thereafter, not labeled in prescribed manner, and the packing bears a statement of false claim for the drug. So in case of these 3 ingredients, it is categorized as misbranded drug. Now coming to the adulterated drug. If the drug is consisting of filthy, putrid, or decomposed substance, please mind these words because these are very technical terms. For sake of understanding this Act, these terms are very crucial and very essential. If you want to decide or determine whether a drug is adulterated or not, the options would be there in a question, that whether such drug which is having a filthy, putrid, or decomposed substance, whether it can be categorized as adulterated drug. Thereafter, the second essential ingredient is stored in insanitary conditions, contaminated, and rendered injurious to health. Thereafter, it is stored in a poisonous container. Thereafter, if it is for coloring but contains a color other than which it is prescribed, and thereafter it contains a harmful or toxic substance, renders injurious to health. Any substance is mixed or mixture with substance, reducing the quality or the strength. So friends, please understand, to categorize a drug as an adulterated drug, it should be a drug having some filthy, putrid, or decomposed substance, or it is stored in a insanitary condition, or even the package or the bottle in which it is stored, it is having a poisonous substance somewhere, and which is rendering it injurious to health, or it is for coloring purpose, but the contents of a color are not as prescribed. Thereafter, it contains a harmful or toxic substance which is rendering it injurious to health. And thereafter, something is mixed, some substance is mixed along with this particular drug, and that mixture has created the particular drug of injurious to health and a lesser quality, or the strength of that medicine is reduced. So if these are the situations, the drug is categorized as adulterous drug. Thereafter, the third category is spurious drug. Now, what is spurious drug? The word itself indicates that a drug which is imported under the name which belongs to another drug, or by labeling it deceptively, or labeling with fictitious name of a company who has manufactured it, substituted drug whole or in part, or it purports to be a product of a manufacturer of whom it is not actually the product. In short, the word spurious is a synonym of deception. That means something which is not true, but you project it as if it is of that quality, or it is from that manufacturer, or you have given some deceptive presentation of that drug on the label or in the drug itself, and that has resulted into a spurious drug. Now take an example that Cipla has got a particular product. The spelling used in Cipla is CIPLA, whereas this particular person, importer or a company, he mentions CEPLA. So a common consumer may not know whether it is Cipla or Sepla, but such type of deception is created. And therefore, all these drugs, which are actually not of that particular company, but you import it on the pretext or on some misrepresentation or some deception, all those drugs are categorized as spurious drugs. Now, if you understand these three concepts clearly, you have to apply these concepts in respect of cosmetics and also the Ayurvedic drugs also. You have to apply these same concepts in respect of manufacturing, sale, and distribution of the product also. What we have discussed so far is in respect of the drugs which are supposed to be imported. So the ban or the provision says that those drugs which are adulterated, which are misbranded, which are spurious in nature, those would not be allowed to be imported. Infrastructure created by this particular act, and if you fail in following these regulations, you will land up in committing offenses, which we will come during our discussion. So therefore, these three concepts and categories, you keep it in mind. Thereafter, let us go to section 10A. It says about the central government special powers. In case it is satisfied or the government is satisfied that there is some risk to humans or animals, and in public interest it is necessary or expedient, then the central government may prohibit any import of drugs, cosmetics from any foreign country. Now, section 12 gives power to the central government to make rules to give effect to these provisions of law. Thereafter, the main part comes under section 13, and that is in respect of offenses. So friends, under the offenses category, anything which is imported and that imported drug is adulterated or is a spurious or is having an ingredient rendering it unsafe or harmful, the punishment is for 3 years and the fine is up to rupees 5,000. Thereafter, if any drug, if it is prohibited under section 10 as per the government's special power, and if such type of drug is being imported, then the punishment is 6 months and the fine is rupees 5,000. Thereafter, under section 10A, notification by the central government prohibiting a drug or a cosmetic, and if that particular drug is imported, then the punishment is, as I have told you, 3,000 and 3 years and 5,000 rupees fine. Also note that there is provision that if you commit repeated offenses for subsequent conviction, first conviction and thereafter again an offense is lodged, and for second conviction, the punishment is very serious. It goes up to 5 years and 10,000 rupees fine. Similarly, there are identical provisions in respect of manufacturing, sale and distribution also. But please note that in respect of import, the cases are conducted before a judicial magistrate first class or a metropolitan magistrate. Whereas in the cases of manufacturing, sale and distribution in India itself, those cases are considered of very serious nature, and special courts and sessions courts are established for those trials and offenses. I will add one more important section at this discussion, and that is section 14. Section 14 speaks about confiscation of consignment in respect of which the offense under section 13 is committed. So section 13 speaks about all these punishments and convictions for importing particular drugs which are prevented or prohibited. So once such type of offense is registered, the concerned authority is having power to confiscate the consignment in respect of the products in respect of which the offense under section 13 is committed. As I have told you, section 15 speaks about the jurisdiction. Such type of offenses are to be tried before JMFC and Metropolitan Magistrate Court as per the case it would be. Thereafter, going to the manufacture, sale and distribution of drugs. This is covered under chapter 4 of the Act. Now again, the standard of quality, misbranded drugs, all that I have explained to you very clearly. Section 16 speaks about standard of quality. Section 17 speaks about misbranded drugs. Please understand the difference between the chapter 3 and chapter 4. Chapter 3 speaks only about the import of all these drugs, whereas chapter 4 speaks about manufacture, sale and distribution of drugs. I am repeating again and again because there is absolutely no much difference about the provisions and the rules in respect of all these aspects. The concepts of standard of quality, misbranded drugs, spurious drugs, adulterated drugs are all same about these aspects. Now, coming to the major provisions, section 18. This is again the prohibition of manufacture and sale, notification by the state government in section 18. So section 10, which was earlier there, it was about the power of central government to put ban on a particular article to be imported, whereas section 18 speaks about prohibition of manufacture of and sale by a notification by the state government in by way of section 18. So section 10 and 18 is to be read together, and to understand, for sake of understanding, it has to be read together. Section 10 is a power of central government. Section 18 is a power of state government. Section 10 is in respect of import. Section 18 is in respect of manufacturing and sale in the state. Now, there are certain responsibilities casted under the Act. Those responsibilities are that these manufacturers or those who are into this particular business, they are duty bound to disclose. They are duty bound to give some disclosures. Like if any offense is committed and they are put to the question that you please disclose the name of manufacturer, or you please disclose as to from where you have procured this material, then the act says under section 18A, the disclosure of the name of the manufacturer is must for this particular person who is dealing into it. Now, coming to section 18B, section 18B speaks about license holder under section 18C to keep and maintain records as prescribed and furnish it to the authority. Now, this is one more responsibility casted on a manufacturer or a trader or a dealer, that if they are having this particular license under section 18C of the act, in that case, they have to maintain the record as prescribed. Whenever the word prescribed is there in the legislation, you have to refer to the rules framed under the act. The rules itself are bulky and they are providing minute details as to, you have to mention from where this particular medicine is procured, from where this particular medicine is brought to the sale or to the dealer. Thereafter, let us go to section 19, which is very important section by the perspective of a criminal lawyer, as to what would be the pleas or the defenses available for these manufacturers or the traders in particular offenses. See, ignorance about nature, substance, and quality. Now, in a general principle, you are aware that you say that ignorance of law do not give any excuse. But if you can establish that I was not aware as a trader, I was not aware as to whether this particular medicine is a adulterated medicine or is a spurious medicine, but under bona fide impression, I have put this particular product for sale. In that eventuality, you could have that defense before the court. Thereafter, you can also take a defense that whatever has been purchased has not been prejudiced, has not caused any prejudice to the consumer, and he brought it for test or analysis. Like a retailer can always take a stand that though this particular person has bought this prohibited material from my shop, but there is no damage caused to him, or he has purchased it only for sake of test or analysis. So if you can establish all that, that also can be a plea or a defense for an accused in such type of cases. Now, let us go ahead with section 20. Government analyst can be appointed by the center or state. Both prior consent of each other is necessary. See, under section 20, government analyst is required to be appointed. Now, this government analyst is having a huge responsibility to carry out the test at the level of government, and those tests or the reports would be very important at the time of criminal trials or even at the time of deciding the genuinity of the product. And in that event, such type of government analyst can be appointed by the central government as well as by the state government. But the officer, if he is to be appointed, then both the governments have to grant consent for appointment of such type of government analyst. Now, coming to section 21, very important section. Section 21 says that the inspector which is appointed under this act, this can be appointed by center or state both. Prior consent of each other for a particular area, prior consent of each other is necessary, and particular area powers are prescribed under the rules. Like inspector, if he is appointed, his appointment has to be by consent. Thereafter, his area has to be determined specifically, demarcated specifically by a specific order. And only then this particular inspector can go and perform his functions of visiting or taking samples or raiding the premises or taking actions, etc. Thereafter, this particular inspector is duty bound or is assigned with the duties of taking samples, which is being manufactured, samples of a product which is being manufactured, sold, stocked, exhibited, or offered for sale, or distributed from a person who is conveying, delivering, or preparing to deliver to a purchaser or a consignee. That means this particular inspector is the most powerful person in this particular act. If he decides that I want to collect a sample, he can make or he can stop even a traveling vehicle and collect the sample. He can visit any manufacturer or even any godown where the stock is stored. He can even visit a or he can even stop a person delivering boy or something is being prepared for delivery. Even that also he can take sample and go for the analysis or testing. Now, for this inspector, there are special powers given in the act. Even for search and seizure of particular material, document, or products, this particular inspector can take help of section 94 of CRPC. Whatever procedure laid down in CRPC, that powers can also be exercised by the inspector. This is a very special power given to him. So under the act and rules, there are already hundreds of powers given to inspector. Over and above all these powers which are mentioned in the act, this inspector can invoke even section 94 under CRPC. Please keep it in mind. Now, thereafter, most important provision. If you try to prevent, obstruct this particular inspector from carrying out his duties, the punishment would be of 3 years imprisonment and fine also. So therefore, you cannot stop this inspector from taking samples from the premises. Now coming to the next portion, I think it is already 7:15. We need to, because this act itself and the provision itself are so lengthy, and I feel that it is my responsibility to just apprise you or just to introduce you about the basics of this particular act, and therefore I am trying to probably elaborate it, but it is taking time. I'll take 10-15 more minutes more and we will finish up by 7:30. Now, coming to the aspects of punishments for committing all the illegalities or breaching the regulations, norms. Sorry, I will just cover section 27, which is very important section. This may be appearing in your examination. See, if section 27 says that if any drug is deemed to be adulterated under section 17A or a spurious under section 17B, and when used by a person for or in the diagnosis, treatment, mitigation, and such use of the drug is likely to cause such harm on his body as would amount to grievous hurt within the meaning of section 320 of the Indian Penal Code, solely on account of such drug being adulterated or spurious or not of standard quality, then such eventuality shall be punishable with imprisonment for a term which shall not be less than 10 years and which may extend to imprisonment for life, and shall also be liable for fine which shall not be less than 10 lakhs rupees or 3 times value of the drugs confiscated, whichever is more. Please focus on this section 27. This section 27 says that if a drug is used and if it is likely to cause a grievous hurt, or by using this particular drug, if death occurs, in that case, the person would be tried for a serious offense and the punishment would be 10 years minimum, and it can extend to life imprisonment. The fine can be not less than rupees 10 lakhs or 3 times of the value of the products which are confiscated, whichever is more. So this is very serious offense which is prescribed under the act. Thereafter, the provision says that whatever fine is recovered, say 10 lakhs rupees or 3 times of the confiscated value, that fine amount is to be paid to the victim who has sustained this grievous hurt, or in case of death, relatives of the victim. So therefore, this provision is giving some benefit to consumers, and therefore this provision is very important from the perspective of examination point of view. Now, coming to one more very important provisions of in the act. Now, section 31, you will have to see once. Section 31 speaks about the confiscation of goods. Earlier also, I have narrated the things about confiscation, but please understand this earlier provision was in respect of confiscation during the trial or on commission of the offense. If the FIR is registered or if the offense is committed, then in that case, during the trial, the confiscation can take place. But section 31 confiscation is in case of conviction. Kindly see the language employed in the section. Where any person has been convicted under this chapter for contravening any such provisions of this chapter, or any rule made thereunder, or as may be specified by rule made in this behalf, the stock of the drug or cosmetic in respect of which the contravention has been made shall be liable to confiscation, and if such contravention is in respect of manufacture, etc. So please note the difference between section 31 and the earlier provision. Section 31 confiscation is in case of conviction only. Now, one more important section, section 31A. Section 31A says that all these offenses, all these provisions would even apply to government departments also, who is into manufacture, sale, or distribution of drugs, except confiscation of provision. So all these provisions would be applied to a government department or manufacturer or a government distributor also, except the provision of confiscation of material. Now, one more aspect. Who can initiate such type of complaint? Now, this inspector, no doubt he can initiate it. A gazetted officer from center or a gazetted officer from state, authorized in writing specifically, he can also initiate such type of complaint. Thereafter, a person who is aggrieved, he can also initiate a complaint. And fourth, the most important, a recognized consumer association. From the consumer point of view, you please understand that a recognized consumer association is having lot of weightage in the act also, and such consumer associations can also initiate prosecution under this particular legislation. Now, there is one more section, section 32A. It speaks about power of court to implead manufacturer or agent, or any person who is concerned in that offense. See, whenever offense is registered, you are well aware that this investigating machinery, sometimes they make accused who is no way concerned with the particular transaction, or who is no way involved in this particular issue. Say some peon or some delivery boy is standing on the shop and he is made accused that he has done some irregularities or breached the regulations. Then the main culprits remained outside this purview of this particular act. So to control and curb this type of escape routes, this section 32 is provided in the act. Section 32 says that during the trial, if the court comes across such type of evidence which points towards the person who is actually responsible, or points towards a person who is concerned or likely to be responsible for these breach of irregularities, in that event, the court is having power to add such person in the entire prosecution, irrespective of section 319 of CRPC. So therefore, please note about this. Thereafter, I will just mention about section 32B, that is about compoundability of offenses. The compoundability offenses is provided in the act. You please have to read it. Because of the time constraint, we may not be able to discuss in detail about that, but compoundability is also provided. And from the point of view of consumers examination, you have to keep it in mind, because now in the Consumer Act, mediation is also provided. So the new legislation encourages ADR. If ADR is to be encouraged, then compounding is having a much higher value. And therefore, please have a focus and study this particular compoundable offenses section, that is 32B. Now, friends, all these methods of trials, offenses, controlling, putting regulations and all that would be applicable to even Ayurvedic drugs, Ayurvedic, Unani and Siddha drugs. The departments or the board for Ayurvedic drugs is completely separate as per the specification in the act. The act has created a complete independent infrastructure. In the same manner, the way we discussed about import part, in section 33B to 33O, and all such type of boards, consultative committees, thereafter disclosures, thereafter regulations in the sale, marketing is provided on the Ayurvedic, Siddha and Unani also. So you will have to focus on that. Friends, now after stopping here about the provisions of Drugs and Cosmetics Act, I must inform you that I tried to find out that is there any question paper available on websites in respect of this Drugs and Cosmetics Act. I must tell you all that Drugs and Cosmetics Act is not covered much in any of the legal examinations, legal law officers examinations, either it is of judicial magistrate first class or a district judge or any type of such judicial officers. But there are such type of questions in the UPSC examinations. In UPSC Civil Services main examination of 2022, there was one question about the latest rules framed on the question I will read, outline the legal framework for protection of online consumers provided under the Consumer Protection Act 2019 and Consumer Protection E-commerce Rules 2020. Friends, this question has appeared in Civil Service Examination of 2022. So this particular question mentions about Consumer Protection Act 19 and also the Consumer Protection E-commerce rules. I will request you all to cover this particular topic for essay purpose also. Now, I will share a objective question list with the organizers. The organizers may put it either on your group or whatever is available mode of doing it. But there are several objective questions. 51 questions are there. These questions I have found out from the Jharkhand Pharma recruitment examination. Those objective questions are asked from the perspective of only pharma examination. But please be mindful that we are concerned with the law topic. So you need not go into the technicalities like which form you have to apply for license, which form is required for this particular aspect and all that. You will have to focus on the points which I have covered during our discussion today. But these objective question papers would certainly be helpful for you. I'm sharing those. Now coming to the essay topics, as I have mentioned in the beginning itself, since the time is limited, now I will request you that please refer, because you have ample time with you for study. Now see these clinical trials in India. There are clinical trial rules incorporated and they are in place. But there are several articles on the website. There are certain blogs on the websites. Even if you can see Supreme Court cases online, journal section, there also you can find so many articles on these clinical trial aspects, which says that our rules are not covering all the aspects which internationally they are covered. For example, I'll just give you one example for that. See, if a drug is to be tested, clinical trials are to be conducted, the consents are required to be taken from such persons. So while taking consents, there are certain communities or there are certain groups which are rustic illiterate. They are not even aware what they are going to face or what result it may occur after taking that particular medicine. So in our rules, whether there are sufficient mechanism provided for undergoing such type of clinical trials is matter of a very serious discussion amongst pharmacists. So we being a lawyer and this being a consumer related issue, you are supposed to examine that whether these whether these clinical trial rules which are provided in India, whether those are sufficient to take care or whether there are certain lacunas in those rules which needs to be rectified. So this is going to be the first topic of essay. You need to study it. You have to read it in various blogs, articles on Supreme Court cases online also. Now coming to the next topic, that is rules and regulations on adversities, particularly for startups. See, startups, they are so enthused people. They are young people. They are coming with innovative ideas. They try to, you know, create something new in the industry. But while doing that, they ignore the rules and regulations in respect of advertisements. You are well aware that in Consumer Protection Act, as well as per the special legislation, advertising field is completely guided and controlled and regulated by law. So whether they are having any exception, whether they can seek exemption from following those advertising rules, and if not, which are the advertising areas or the rules or the act they are supposed to follow. On that also you have to study, find out certain points for essay. Same way on SCC online, so many articles are available. Please have a look at it. If given an opportunity, I would be happy to discuss all these articles with you, but time constraints are there. Now, the most important topic, ban on e-cigarette. See, you are well aware that nowadays, if you wander around Mumbai also, young generation, they use such type of pens, and the pens are put in mouth, and then and suddenly the vapors come out of it. So those are e-cigarettes. We are not even aware that how these e-cigarettes works, but there is a heating component, there is a chemical inside. Those heating component gets activated with a switch, with a button. After heating, that chemical gets activated, vapors are released. Those vapors are inhaled to the lungs by young generation, and then such type of e-cigarettes are created with various different flavors also. But in September 19, special legislation was brought by the central government, and such e-cigarettes are put to complete ban. Now the research says that e-cigarettes and a normal cigarette, the effect is almost same. Rather, the study suggests that the adverse effect of e-cigarette is 5% lesser than the normal cigarette. If that is the case, how can you put complete ban on e-cigarette? That was the area of discussion in some community. So therefore, again, the Drugs and Cosmetic Act comes into play. The Drugs and Cosmetic Act says that if a particular device or a particular medicine or a particular drug, if it is injurious to health, if it is trying to be damaging to the young generation or to a human being, then the government in public interest can put complete ban. So using this exception, the government has put complete ban on e-cigarette. But whether it is validly done or no, whether the Drugs and Cosmetics Act, as per the definition, it mentions about the device. So whether this particular device like a pen, which is a e-cigarette, or even a pen drive like a thing, which is an e-cigarette, whether that can be mentioned as a device under the definition of Drugs and Cosmetics Act. Very interesting topics these are. You need to study. You need to study on the various blogs and articles, and you will find ample material. But I feel that if the examiner wants to put certain question in respect of writing a essay on this particular topic, these are very burning topics which the examiner may put for your scrutiny, and you may be asked to write an article on this or an essay on this. Now, the last topic which I may cover is in respect of telemedicines, e-pharmacy, or the robot-assisted surgeries. In the beginning itself, I mentioned that now after COVID and pandemic, the way we approach to doctor is completely changed. Now people prefer to call a doctor and take medicine. Apart from that, 75% of the medical infrastructure is situated in urban areas, whereas the rural areas, the villages, they are being prevented, they are not able to enjoy the advanced medicine or medical facilities. In such situation, can a person who is staying in rural area, can he be operated by a surgeon who is sitting in Mumbai? So that is also a matter of new concept, which is, and what is the law guarding and governing all these aspects? Under Consumer Protection Act, can a consumer come to consumer court and say that, see, this medicine I requested for a doctor and this doctor has prescribed this medicine, but this has adversely affected my health? So would it be making that doctor subject to certain compensation? Would it be a case of serious uh, misconduct? So all these aspects are required to be studied. So I request you, I I hope that these topics or these bird's eye view or these provisions of Drugs and Cosmetics Act, whatever we discussed today, would have helped you a little, or probably at least cleared the fear in your mind that this Drugs and Cosmetics Act is a very difficult subject. Probably, if that fear is removed from your mind today, I feel this would be the success of today's discussion. And I wish you a very good luck, a very good time for your study. And I hope that all you lawyers would come there as a judges, members, and uh, the responsible persons to handle the Consumer Protection Act. Thank you very much.
Thank you, sir. First of all, I should thank Bar Council for having organized this lecture. And secondly, I thank Tejas Dande, sir, from the depth of my heart for the reasons that this act, if we read the name itself, makes us feel that it is a very difficult act. But the way he explained it today, every provision was explained in such a beautiful manner, and the nuances of the act were explained in such a beautiful manner that it was made so simple. I was reading through the chats, and I understand even the students were stick to the seats because of that. Thank you very much, sir, for having made it, and thank you for your support in the manner in which you have explain to them what kind of questions will come in the act, what kind of topics would be covered for the exams. Thank you very much, sir.
Thank you very much. Whew.